Hi, Matt suing from Estate Law Partners to walk you through the difference between a will and a trust. One of the things I hear all the time is that having a will avoids probate. This is a mistake. Most people don't realize that a will only transfers certain assets we call probate assets, and that it does nothing until after you have passed away and the will has been admitted to the probate court. What we need to do here is make a distinction between probate assets and non-probate assets. Probate assets are typically untitled or just titled in your name. The key is that there isn't anything built into the asset or so closely associated with it to answer the question of who gets it when the owner dies. Non-probate assets, on the other hand, do have a built-in answer to the question of where it goes. For example, jointly owned property that passes through a beneficiary designation, or as we'll see in a moment, assets that are held in trust. The will is a document that says where your probate assets go after you die. It also names an executor who is responsible for the probate. You can think of the will as an answer key to where your probate assets should go under the supervision of the probate court, since there's not already a built-in answer. To administer a will, it must be admitted to probate by the courts, and permission must be granted for your personal representative or executor to act. Now, how does a will compare with the trust? Well, a trust is a legal entity that controls the distribution of property outside of the probate process. The goal with a trust is to avoid probate. I like to refer to it as a bucket or a funnel. So the planning we do is we create this bucket, and then you take what you own and put it in the bucket or the funnel during your lifetime. You put your checking, your savings, your real estate investment accounts in this bucket. And then the law says that if you become incapacitated or die, it does not need to go through the probate process. The trust document itself names a successor trustee who can carry out your playbook without needing to get permission from the courts. Your instructions say how the assets flow out of that funnel. A trust is a private document and does not become part of the public record. The assets owned by the revocable trust are distributed without any notice to your unsecured creditors. Therefore, trust administration is more efficient and costs substantially less. I also think challenges to trust are less likely to occur than they are with a will, since you are administering your affairs outside of the court system. Now, just as a reminder, even if you do have a trust, that does not mean you don't need a will. Your will is a backup document that still directs any probate assets to your trust. We nickname those pour-over wills. For parents of minor children, the will is where we nominate guardians, since guardianship has to go through the courts. I appreciate your time listening and welcome you to contact us at estatelawpartners.com for help turning any probate apples into non-probate oranges.